morning. This is Srikanth signing in for contracts. In our previous classes, we are discussing about the conditions of the contract. Whenever a contract has to be entered into, it has to satisfy certain essential elements under section 10. So to constitute a contract, certain conditions are to be satisfied, namely two parties, consensus ad idem, capacity to contract, free consent, lawful consideration, legal relationship, lawful object, terms must be certain, and possibility of performance. We have seen all the 6 conditions. Today we are going to analyze the another condition, which is lawful object or legality of the object. Whenever you are entering into a contract, it must be lawful. Unlawful contracts are unenforceable. So a contract to be valid, the object for which it has been entered into must be lawful. Unlawful contracts or illegal contracts are unenforceable. So, according to section 23 of the Indian Contract Act 1872, an agreement entered into with a lawful consideration or object is declared void if it is forbidden by law, defeats any provisions of law, fraudulent, causing injury to person or property of the another, or immoral or opposite to public policy. That means you are entering into a contract that has been forbidden by the law. Forbidden means prohibited by the law. For example, if you want to enter into a contract for purchase and sale of lottery tickets, it was prohibited by the law. Now, the law has prohibited the purchase and sale of lottery tickets. So, if you enter into a contract for purchase and sale of lottery tickets, it is forbidden by law. Hence, it is unenforceable. That means even though if you enter into a contract, it satisfies all the essential conditions, still it is prohibited under the law. So any contract forbidden by law is void. Next, defeats any provisions of law. Law is there. If you enter into a contract so as to defeat any provisions of the law, remember, anything cannot go above the law. So, if we enter into a contract to defeat any provisions of law, it is void. Number 3, fraudulent. So, contracts to commit a fraud is always void. And number 4, if you enter into a contract so as to cause injury to person or property of the another, it is void contracts. And lastly, if it is immoral or opposite to public policy, even these contracts are also unenforceable. In the entire crux, if you want to enter into a contract, the object should be lawful. So an agreement entered it with unlawful consideration or object is declared void. So we have seen, if a contract is forbidden by law, if it defeats any provisions of law, if it is fraudulent, if it causes injury to person or property of the another, or if it is immoral or opposite to public policy, then the contract will be declared as void. An agreement entered into against the interest of the general public is deemed to be opposite to public policy. If it creates any damage to the general public, then it is deemed to be opposite to public policy. Any contract which is opposite to public policy is null and void. In other words, an agreement which is harmful to public welfare is said to be opposite to public policy. Remember, any agreement which is harmful to public welfare is said to be opposite to public policy. So, such agreements are agreement in restraint of trade, agreement in restraint of marriage, agreement in restraint of legal proceedings, wagering agreements, agreement to commit a crime, and agreement with align. Why these agreements which goes against public policy? Restraint of trade, agreements in restraint of marriage, agreement in restraint of legal proceedings, wager agreements, agreements to commit a crime, agreement with align enemy. If you enter into these sort of contracts which prevents, then the contract is declared to be void. Let us analyze one by one. So, the first point is agreement in restraint of trade. So, in this connection, we have to think about the constitution. Under the constitution, we have been given certain fundamental rights. So, Article 21 and Article 19 speaks about freedom of profession, freedom of trade, everything. So, any person have a fundamental right under the constitution to carry on any trade, profession, occupation. So, if this goes against the fundamental rights which has been guaranteed under guaranteed under Article 19 and 21, it is void. Remember, anything which goes against the constitution, it is invalid. So, if you take section 27 of the Indian Contract Act 1872, it says every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. So, carrying on the trade is your fundamental right, and if you enter into an agreement not to carry any lawful profession or trade or business, it is void. So, agreement in restraint of trade is void. Why? It goes against the fundamental rights. Number 2, agreement in restraint of marriage. Section 26 speaks about it. Again, marriage is your fundamental right which has been guaranteed under Article 21. Why? Marriage is not only a sacrament and sacrosanct but also a civil contract. An agreement or contract to marry is valid subject to fulfillment of certain conditions. That is, Hindu marriage is valid subject to fulfillment of conditions under Section 5 Hindu Marriage Act 1955. Any agreement or contract in restraint of marriage is opposite to public policy and it is void. For example, A promises to pay 50,000 rupees to B if B does not marry anyone and remains unmarried. So, now you are entering into an agreement with B that B should not marry, which goes against his fundamental rights. So, if it goes against the fundamental rights, it is void. So, any agreement in restraint of marriage is void. Again, agreements in restraint of legal proceedings. Any person have a right to go to the courts of law. So, if you enter into a agreement with any person not to go to the court of law, again it is void. According to section 28 of the Indian Contract Act 1872, every agreement by which any party is restricted absolutely from enforcing his rights under any contract by the legal proceedings in the ordinary tribunals, or which limits the time within which he may thus enforce his rights, is void. For example, A is there, B is there. Both enter into a contract. A tells to B, don't go to the court if I don't pay the money to you. That means A is putting a imposition on B not to go to the courts of law. That means B should not go to the courts for his enforcement of his rights, again, which goes against the articles of the constitution. So remember, in India, every person has a right to carry on any trade, occupation, or profession. Any person is having a right to marriage. Any person can approach the courts of law. So, if you make an agreement in restraint of trade, if you make an agreement in restraint of marriage, if you make an agreement in restraint of legal proceedings, then definitely it is void. Number fourth, agreements void for uncertainty. So remember, a contract to be valid and enforceable, the terms of the contract or agreement must be clear and certain. So unambiguous agreements are only enforced. Ambiguous agreements are unenforceable. Section 29 of the Indian Contract Act 1872 envisages that the agreements, the meaning of which is not certain or capable of being made certain, are void. So, if you want to enter into a contract, the terms of the contract, the clauses of the contract must be clear, unambiguous. If it is ambiguous, the terms are not clear, the terms are uncertain, it is unenforceable. Let us take an example. A agrees to sell to B 100 tons of oil. Here A and B are entering into a contract. A agrees to sell to B 100 tons of oil. Here there is nothing whatever to show what kind of oil was intended. Coconut oil or what is called groundnut oil, sunflower oil, nothing is there. Simply they entered into a contract for supply of 100 tons of oil. So here the agreement is void for uncertainty. So the terms of the contract, the clauses of the contract must be clear and ambiguous. Number 5, agreement to commit a crime. An agreement to commit a crime is an illegal contract. Again, an illegal contract is one which is immoral or against the law. An illegal contract is void and it is also a crime under section 120A, criminal conspiracy of the Indian Penal Code. An agreement to commit a crime is not only void but also an offense. However, every void contract is not illegal. Remember. So, an agreement to commit a crime, it is an illegal contract. Illegal contract goes against the law and it is immoral and it is not only a void but it is also a crime under section 120A, criminal conspiracy of the Indian Penal Code. Right? Next, agreement with alien. So let us see what it is. When there is a war between two countries, it is unlawful and against public policy that the person should trade with subject of the enemy country. So agreements with the enemy country are not made unlawful. Then the commercial transactions between the two countries are also put in abeyance. So if you cannot enter into an agreement with an alien country where there is a war is going on between these two countries. Next is wagering agreements. Wagering agreements has been defined under section 30. Wager means bet, bet, bet. So, wager means a promise to give money or money's worth upon the determination or ascertainment of an uncertain events. We will discuss a separate chapter is there on wagering agreements. We will discuss this in later. So, legality of the object or lawful object, agreement in restraint of trade is void. Agreement in restraint of marriage is void. Agreement in restraint of legal proceedings are void. Agreements are void for uncertainty. Agreement to commit a crime, it is not only a void, a crime under Indian Penal Code. Agreement with align is void and wager agreements are void. Next condition is terms must be certain and it should not be vague. The terms and conditions of the contract shall be clearly furnished in the agreement without any ambiguity or vagueness. In other words, the terms of the contract must be clear and certain. If it is not clear and certain, it is not valid and enforceable. So here, whenever you are entering into a contract, the terms and conditions should be clear without any ambiguity. Clearly, you have to mention everybody's obligation, that is, offerer's obligation, acceptor's obligation. If it is not clearly mentioned in the contract, the terms of the contract are uncertain, the terms of the contract are vague, the terms of the contract are with ambiguous terms, then subsequently the contract cannot be enforceable. Let us take an example. A and B is there. Both entered into a contract for supply of oil. A offers B to supply 100 tons of oil. Now, in this example, terms of the offer are not clear. Why? Since the nature of the oil is not mentioned here. That means whether A is offering coconut oil or groundnut oil and B is purchasing whether coconut oil or groundnut oil. So, terms must be certain and not vague. If the terms are unambiguous, definitely contracts are enforceable. If the terms are ambiguous or terms are with vagueness, if the terms are unclear and uncertain, it is not valid and enforceable. Yes, students, you understand this? So, terms must be clear, certain, unambiguous, and without any vagueness. So, have a good day. This is Srikanth signing off today.